You are busy continuing with your studies. Today's summary is going to be about the interest of the children of divorcing parents. This will just be a quick summary, and as always, I've done the summary notes, and if you want these notes, you are free to send me an email on at Monarkn, MONARKN, at unisa.ac.za, and I will share the notes with you. The important information that you should know, but please make sure that you study the whole chapter, you study the study guide, as the exam question will consist of randomized questions. That basically means that we can ask anything. But on this summary, I've just summarized the most important aspect that as a legal practitioner, you need to be aware of. When it comes to children, the child's best interest is paramount. It is the most important factor, the most important aspect in everything that has to do with minor children. Child best interest is paramount. Basically, we are saying the primary consideration it is the primary consideration in all actions concerning minor children. Remember, minor children are all individuals who are below the age of 18 years. As long as an individual has not turned 18 years, they are minor children. The legal instruments that deal with minor children with the best interest of children are Section 28, subsection 2 of the Constitution of South Africa, Sections 6, 7, and 9 of the Children's Act, the Convention on the Elimination of All Forms of Discrimination Against Women, the Convention on the Rights of the Child, and the African Charter on the Rights and Welfare of the Child. Please be aware and study Section 7, subsection 1 of the Children's Act, which consists of factors that are taken into account in determining what is in the best interest of the children or of the child. The mediation incident divorces matters. This legislation or this statute mainly deals with the roles of the family advocate. The family advocate is always involved in matters where the parents are divorcing and there are minor children. If the parents are divorcing and they've entered into a settlement agreement, that settlement agreement has to be endorsed or approved by the family advocate. If the divorcing spouses, the parents, have not entered into a settlement agreement and there is a dispute regarding who should have access or contact with the minor children and who should have primary residence with the minor children, the matter has to be referred to the family advocate's office. Remember, please note the correct terms. We no longer have terms like access. We no longer have terms like custody. We now have contact. We now have primary residence, but we still have terms like guardianship. Now, back to the family advocate. The purpose of the family advocate is to furnish the court with a report and recommendation on any matters concerning the welfare of the minor child or the minor children. The family advocate may lodge an inquiry in terms of the Mediation in Certain Divorce Matters Act and in terms of Section 6, subsection 1, subsection B of the Divorce Act. The request for an inquiry to be held may be made by, firstly, the court can give an order that the family advocate hold an inquiry, or the parties themselves can actually can approach the family advocate to request that he or she or the family advocate's office holds an inquiry. And when the parties do that, they have to complete a form is known as Annexure B. That is a form where parties request the family advocate to lodge an inquiry regarding any aspect of the minor children. With the exception of maintenance matters, the family advocate does not deal with maintenance issues. And also the family advocate, they can hold an inquiry if they request permission from the court to conduct an inquiry. And this permission, they must request it if they are of the view that it is in the best interest of the minor children that an inquiry be held. So the family advocate can hold an inquiry under three circumstances. Firstly, if the court gives an order, if the parties themselves approach the office of the family advocate, or if the family advocate's office itself approaches the court and requests that they hold an inquiry. And this is when the court has not on its own, like given an order for the family advocate to hold an inquiry, or the parties have not approached. But looking at the circumstances, the family advocate will be of the view that, under these circumstances, we must hold an inquiry, but they cannot hold an inquiry without the permission of the court or without getting an approved court order first. In the case on Van Vuuren versus Van Vuuren, the court held that the family advocate must request for permission from the court to conduct an inquiry in the following circumstances. Firstly, if the care of a young child will not be awarded to the child's mother, or secondly, if the issue involves separations of siblings, and thirdly, care will be awarded to a person other than the child's parent. And fourth, an arrangement regarding care and contact that will not be in the child's best interest. Now, let's move to the Divorce Act. Section 6 of the Divorce Act regulates the position of a minor or a dependent children born of divorcing parents. It is important to note that Section 6, it is not applicable to step children. So in other words, it is applicable to the biological children or children who have been legally adopted by the divorcing spouses. Section 6, subsection 1, subsection 8 states that the court must be satisfied that an arrangement has been made regarding the welfare of the minor child or dependent child. This is when I started, I said that spouses who are divorcing, they can enter into a settlement agreement. So those who have entered into a settlement agreement, the family advocate must endorse the settlement agreement. So that's just to make sure that the settlement agreement has a section that relates to the minor children, and whatever the agreement the parties or the divorcing spouses have entered into, it is in line, or it is in the best interest of the minor child. And if spouses do not have, if the spouses do not have a settlement agreement, then the inquiry will have to be made. The inquiry will have to be held. So this is why in every divorcing matter, the divorce will not be granted until the family advocate has ensured and given a report that the welfare of the minor children have been taken into consideration. Now, moving along to aspects the court may regulate, let me go up. Section 6, subsection 3 of the Divorce Act provides that the court which makes a divorce order may make any order it deems fit in respect of the maintenance of a dependent child of the marriage or guardianship contact with the minor child and primary residence. Please make sure that you know the terms and what they mean. Primary residence, parental responsibilities and rights, guardianship, care and contact, and maintenance. These are important concepts when it comes to minor children and their parents or guardians. Please make sure that you understand what this concept means. You also need to understand, please thoroughly read your prescribed textbook and the study guide. Make sure also that you understand that how can enforcement of guardianship, care and contact be done. For example, there can be an interdict, a compliance order, a reasonable force can be used, and there also can be criminal sanctions. Now, rescission and suspension and variation of an order made upon divorce. Section 8, subsection 1 of the Divorce Act provides that the court may rescind or vary an order regarding guardianship, care, contact, or maintenance, or suspend a maintenance order or contact made upon divorce if there is sufficient reasons to do this. Lastly, please be aware that there has been legal developments made by the Supreme Court of Appeal in the case of Z versus Z, which is a 2022 judgment. This case, it is discussed in tutorial 102. So students, when you study for the exam, please ensure that you study your prescribed textbook, you study your study guides, you study your tutorial letters, and any other relevant and important documentation, like for example, the summary notes that maybe you have drafted yourself or that you have obtained from me or my other colleague, if there is any summary notes. And please be aware that the exam will be a multiple choice exam consisting of randomized questions. It will be an open book exam. As I always advise you that when you study, the first thing that you need to do is study to understand. Don't study to cram. Don't study to just, assume that this type of questions will be asked and then you start guessing the answers. Study to understand. Once you understand, or you just have a basic understanding, then when you study again, it's going to be easy for you. It's going to be easy for you to navigate, including during the exams when you find questions which maybe it's about any of the study units. It's going to be easy for you to go to your textbook, go to your all other relevant study materials to actually understand the question and maybe to even guess or point out the correct answer. The trick in family law is just make sure that at least you firstly understand. Once you understand, like for example, what we're talking about today, if you can just have a basic understanding of, okay, this is the role of the family advocate. If you can have a basic understanding, okay, this is what the terms, when they talk about parental rights and responsibilities, this is what they're talking about. When they talk about guardianship, contact, primary residence, care, this is what they're talking about. And once you have that, it's going to make it easy for you when you taking your exam. Yeah. Student, this was just a quick summary regarding this study unit, of the interest of the children of divorcing parents. Good luck with your studies. And should you need to talk to us, either me, Kathleen Munari, or my colleague Mulebukeng Sierrane, on any of the study units, if you need clarification on anything, please feel free to send us an email. Good luck, students, and all the best. Goodbye.